Have you ever wondered if the line between your personal online life and your professional one is truly private? In today's digital world where sharing is commonplace, it is a question many of us quietly ask. The direct answer is yes. In many situations, your employer can indeed monitor your social media activity, but there are important legal boundaries and considerations to understand. It is not a free-for-all. The primary reason employers can monitor your social media stems from a few key areas. First, if your posts are publicly accessible, then generally an employer can view them just like any other member of the public. There is no expectation of privacy for information you share openly. Second, many companies have robust social media policies that employees agree to follow as a condition of employment. These policies often outline what is considered acceptable online behavior, especially when it relates to the company's reputation or business interests. However, some state laws provide specific protections. For instance, many states have laws prohibiting employers from demanding your personal social media passwords or requiring you to add them as a friend. These laws aim to protect your private accounts. Employers also have a legitimate business interest in preventing harassment, protecting trade secrets, or upholding their brand image. If your social media activity interferes with these aspects, it can become a workplace issue. It is also crucial to remember the National Labor Relations Act, often referred to as the NLRA. This federal law protects your right to discuss terms and conditions of employment with coworkers, whether online or offline. This means if you are talking about wages, hours, or working conditions with colleagues on social media, your employer generally cannot discipline you for it even if it is negative. This is known as protected concerted activity. So what can you do? Start by thoroughly reviewing your company's social media policy and acceptable use guidelines. Understand what they expect. Adjust your privacy settings on all your social media platforms to control who sees your content. Consider separating your professional and personal online identities, perhaps with different accounts or stricter privacy for personal posts. Think before you post. An interesting nuance is how quickly this legal landscape is evolving. Courts are continually interpreting these privacy rights in new digital contexts, making it a complex area. Understanding your state's specific laws regarding employer access to personal accounts can provide an extra layer of protection. For instance, laws in states like California or New York offer employees stronger privacy protections than in states without such specific statutes. Ultimately, navigating social media as an employee is about balancing your right to personal expression with your professional responsibilities. By understanding your employer's policies, the scope of their monitoring capabilities, and your legal protections, particularly under the National Labor Relations Act, you can proactively manage your online presence. This empowers you to protect both your privacy and your professional standing without fear of unexpected consequences.